So Jim, my question is easier to ask if I unmute my my computer. So when I know Melanie is going to read in the public comments, how does it work? Can anybody else? Can we take additional comments, or people can hear us, or is it just us, or this is a little bit different system?
Yeah, it's my understanding, Melanie can correct me, but we will be inviting public comment on the telephone as well.
Okay, good. Thank you.
Mr. Chairman, I have a quick question.
Yes.
During the discussion of the case itself, are non-settling parties, if they were to chime in, I wouldn't know which parties are which. Is there a way to deal with that if any of the represented parties are on the line? I mean, they should go during public comment, but how would we know if they are chiming in on an agreement they're not a party to?
Okay, maybe what I'll do is take that suggestion and ask people if they are party to this settlement or not a party to the settlement, so we all know up front. Would that be satisfactory? Okay.
I apologize, we're still working on a couple little things and then we can start. So thank you.
This is Tina. I think we're ready and live on YouTube now. Thank you.
Okay, thank you, Tina. At this point, I'll call the Tax Commission meeting to order. There's some items on the agenda that I know lots of us will be interested in having a conversation about. Melanie, is there anything that you need to do as far as swearing in witnesses or anything ahead of these proceedings?
Yes, if you'd like me to administer the oath right now, I will.
Please.
And it's a declaration for anyone who is testifying here today that by testifying in this meeting, you are attesting that you will swear to tell the truth in the proceedings here today. Thank you.
Okay, thank you, Director Young. At this point, I believe, George, did you want to make a comment before we got started, please?
Yes, thank you, Mr. Chairman. I wanted to advise the commission that I've been listed as a witness in the pending litigation. I discussed it with our counsel, Rosalie. I don't believe that it impairs me in any way to be impartial in the matter, so I plan to participate.
Okay, thank you. Thank you, Commissioner Klassis. Is there any other commissioner that feels they have a conflict of interest? Could you let me know that now? Okay, hearing none. At this point, I'm going to turn it back over to Director Young for a few minutes, probably more than a few minutes, as she's got some comments that we need to read into the record. So Director Young, I'll throw it over to you.
Thank you. We're going to enter into the public comment section of the meeting. And what I'll be doing is reading in the public comment that's the written public comment that's been received so far. And what I'd like you to do, Chairman, is also time myself. You're going to time the public comment to 3 minutes. And so if you'll let me know if I exceed the 3 minutes on any one of these individual items, I would appreciate that. So the first item being read into the record is from July 30th, 2020, and it's written to Chairman DeVold and the members. On behalf of the Nevada Cannabis Compliance Board, CCB, I appreciate the opportunity to submit written comments for the record before the July 31st, 2020 Nevada Tax Commission meeting. The settlement agreement you are deliberating on today has been reviewed by the CCB. Although the issues at hand predate the CCB, the board understands the department's desire to move forward and bring to a conclusion ongoing litigation. We have reviewed the requirements set forth in the agreement, including those that bind the CCB, and are committed to executing those obligations stated therein. Sincerely, Tyler Klimas, Executive Director from the Nevada Cannabis Compliance Board, CC'd, Honorable Michael Douglas, Chair. The next item is listed as public comment, and I would like to state on the last one that I read is available on the department's website. The next item to be read as public comment is also available on the department's website. And it is from John A. Hunt, and it's addressed tax commissioners. Regarding the Nevada Tax Commission meeting scheduled to be convened tomorrow, July 31st, 2020 at 2 p.m., attached, and in reference to Agenda 2, demand is hereby made that copies of any and all public documents and associated supporting materials, which will be reviewed by the members of the Tax Commission in deciding whether to reject or approve Agenda Item 2, will be forwarded by reply mail to John A. Hunt, Esquire, of the law firm of Clark Hill, PLCC. Such public documents must be produced to provide the opportunity for meaningful public comment as required by the Nevada Open Meeting Law and as required by Agenda Item 1. Such responsive copies of the public documents requested include, but are not limited to, the partial settlement agreement to be considered, including any publicly available exhibits or attachments. Any supplement, item number 2, any supplements or supporting materials related to the proposed partial settlement agreement. Item number 3, any other related settlement agreements between the parties the state maintains in its possession. In the event the state does not possess any related settlement agreements between other parties to the litigation, any public documents or correspondence related to any such proposed agreement. Item number 4, any communication between the state and Live Free regarding the limited Henderson license identified in paragraph 2 of the agreement, including, but not limited to, any correspondence, policy, or interpretation relating to any purported authority by the state to issue an additional conditional license not subject to a competitive and numerically scored review of competing applicants, was required by NRS 453D.210, Section 6. Item number 5, any public document and or supporting materials relative to the change of ownership requests submitted by Greenmark, which the subject of, let me start over. Item number 5, any public document and or supporting materials relative to the change of ownership request submitted by Greenmark, which the subject of the provisions of paragraph 6 of the proposed partial settlement agreement. Item number 6, any public documents and or supporting materials relating to the state's determination that the enjoined parties identified in paragraph 7 who failed to submit applications in complete form such that the applications could not be properly evaluated, scored, and ranked can now be deemed to have satisfied DOT's requirements. Item number 7, any correspondence to tax commissioners in favor or in opposition, and any emails or text received by any of the tax commissioner, which they have taken into consideration in determining whether to reject or approve Agenda Item 2. Time is of the essence to receive the requested public documents and to enable meaningful public comment. particularly in light of the Tax Commission only providing the minimum 3-day notice to conduct the meeting set for tomorrow as required by the Nevada open meeting law. While the OML does not require supporting materials such as a settlement agreement to be appended to or attached to the publication of the public body's meeting notice and agenda, members of the public may request copies of supporting materials before or during the meeting, which then imposes a duty to provide copies of any such supporting materials. See AG file number 10-008, May 3rd, 2010. In the event the state is unable to provide the requested documents prior to the scheduled meeting, we respectfully request that the Commission defer action on requested approval of the proposed settlement until the requested materials and meaningful public comment can be provided. Lastly, pursuant to Agenda Item 1, I'm requesting the content of the email be read into the record as my public comment as authorized by Agenda Item 1. I have read the contents of this email out loud, and the time required to read it into the record is less than 2 minutes. Thank you. I look forward to receiving the responsive public documents as soon as possible. John A. Hunt. Moving on to the next item to be read into the record. This one is also available on the department's website. This is from Amy Sugden, and it's written, Dear Tax Commission, as extensive plaintiffs in the case entitled in Department of Taxation, case number A-19-787004-B, pending in the 8th Judicial District Court, THC Nevada, LLC, and Herbal Choice Incorporated hereby submit their public opposition to the proposed recommended settlement as submitted to the Tax Commission. In particular, THC Nevada and Herbal Choice submit that there are numerous issues of grave concern that should prevent the Tax Commission from attempting to consider sanctioning this proposed settlement. These are set forth as follows. Item number 1, the partial settlement agreement has not been approved by the court. Thus, any purported approval by the Tax Commission is premature. The district court must approve the settling plaintiff's request to dismiss their complaints against the Department of Taxation and other intervener/defendants pursuant to NRCP 41A2, which requires that the court issue an order of dismissal on terms that the court considers proper. THC Nevada and Herbal Choice submit that is written, the partial settlement agreement, which is the basis for the stipulation of dismissal, will not garner approval by the court. Item number 2, in particular, the court cannot sanction a settlement that supports ethical violations, breach of professional conduct of counsel of the settling plaintiffs, as discussed in more detail in the attached briefing submitted before the court. That is also available on our website. Section number 3, the court cannot sanction a settlement that condones dubious behavior by the parties to the settlement, including the Department of Taxation, to work around the court order injunction and joining these certain licenses, those certain licenses that were issued in a contravention of Nevada law. See paragraph 46 of the August 23rd, 2019 findings of facts and conclusion of law granting preliminary injunction enclosed here too. Finally, it is unclear how the Tax Commission can approve such a settlement that binds the Cannabis Compliance Board, CCB, repeatedly, and the CCB is not a signatory to the agreement. It is our understanding that the CCB is designed and intended to be an independent agency that the governor created for the express purpose of reforming and strengthening Nevada's cannabis industry. By the way, in which the CCB is referenced 38 times in the settlement agreement, evidenced otherwise. Moreover, the manner in which this attempted settlement agreement has been negotiated and the significant terms that bind the CCB, given the public concern that the CCB is not, in fact, independent as intended by the governor. Accordingly, we respectfully request that the Tax Commission refuse to consider this matter in the event they decide to, specifically to the public, the authority it relies on to determine that the Department of Taxation necessitate the Tax Commission approval of the effect thereof. As under the law, we assert that Nevada, the Department of Tax has no say in this matter as of July 1, 2020. Respectfully, THC Nevada, LLC, and Herbal Choice, Incorporated via counsel Amy L. Sugden and Sigal Chattis. Moving on to the next item to read into the record. This is from Ross Miller, written on behalf of 7 locally owned and operated cannabis companies, urging you to defer any action today. Ultimately, we only ask that you defer action until your next meeting. Under the guise of some apparent government emergency, the Tax Commission has been summoned to a special meeting, but given only 3 short days to consider a decision that may literally determine the future of an industry and indeed the regulatory reputation of our state. To be clear, this so-called emergency agreement won't even end the state's involvement in the legal battle. Irrespective of the decision you make today, the state will still be engaged in this litigation. There are 3 points relative to the agreement you are asked to approve. Number 1, this emergency settlement agreement does not settle the case, and the state is getting very little, if anything, worth in the settlement. The remaining plaintiffs can and will proceed with all of the claims against the state. The settling parties have no ability to resolve these claims without the consent of the remaining plaintiffs. As proposed, the partial settlement actually substantially hinders the state's ability to resolve the case because it allocates all, or virtually all, of the licenses of interest to some of the plaintiffs, leaving the remaining plaintiffs with no reasonable relief. Item number 3, the settlement agreement requires the state to commit things that are factually false and/or violate state law. These points are more substantially raised in a motion we filed before the court requesting an injunction of today's hearing. To be clear, that we knew the court would likely not be inclined to take such an extraordinary step of enjoining your decision, but the attached motion nevertheless outlines some of the myriad of serious issues with the emergency settlement agreement. The decision is ultimately before your body and should not be approved. Please defer action on any approval. There is simply no justifiable reason to rush approval of such an important agreement. Ross Miller. Here, an additional request to be read into the record. This is from Rob Lauer, and this one came in after the time frame to have the item uploaded on the website. So this is not on the website yet. So commissioners, please describe how and why your agency retains any jurisdiction over cannabis license litigation following the creation of the Cannabis Compliance Board under Assembly Bill 533. You are no longer the controlling authority, correct? ? Direct from AB 533, transferring the authority to license and regulate persons and establishments engaged in certain activities relating to cannabis from the Department of Taxation to the board. There's a link to, looks like Nellis, where the bill is located, and it says regards, Rob Lauer, political reporter, 630 News, Las Vegas. The next item is uploaded on the department's website, and it is from a retired Reno cop And it's public comment for Tax Commission July 31st from Jeff Church at www.renotaxrevolt.com. The subject matter is Reno Business Improvement District, BID. From the Nevada Department of Taxation, after consultation with Deputy AG, at a minimum, the Reno BID/DMO is subject to the jurisdiction of the department pursuant to the Local Government Budget and Finance Act pursuant to NRS 354.4741, subsection 1. For instance, the creation of a special assessment/local improvement district pursuant to NRS 271 would appear to trigger budget reporting responsibilities for contracts associated with the expenditure of the special assessment levies pursuant to NRS 354.5965. NRS 354.474, applicability to local governments. Local government defined: 1, except as otherwise provided in subsections 2 and 3, the provisions of NRS 354.470 to 354.626 inclusive apply to all local governments. For the purpose of NRS 354.470 to 354.626 inclusive, A, local government means every political subdivision or other entity which has the right to levy or receive money from ad valorem or other taxes or any mandatory assessment, and includes without limitation cities or counties, cities, towns, boards, school district, and other districts organized pursuant to chapters 244A, 318, 318A, and 379 of NRS. NRS 450.550 to 450.750 inclusive, and chapters 474, 541, 543, and 555 of NRS, and any agency or department of a county or city which prepares a budget separate from that of the parent political subdivision. From the City of Reno. The City of Reno Business Improvement District, BID, is managed and operated by the Downtown Reno Partnership, a private nonprofit downtown management organization, DMO. Comments from Jeff Church, www.renotaxrevolt.com. The unelected BID/DMO board, not the city, determines any increases in assessments. The assessments apply to all private properties, including non-business condo owners, vacant land, and churches that are otherwise tax exempt, and most government properties in the BID area. Thus, taxpayers countywide pay taxes to support the BID. The BID pays for Reno police officers, but those services are subsidized by taxpayers citywide. The DMO is a 501c6 advocacy alleged nonprofit, but has no members. See bylaws, it is not a 501c3. Whereas the Department of Taxation has determined that the BID/DMO is a local government per NRS 354. I urge the Tax Commission to agendize and take a close look at the BID/DMO. Please look at the question of how can a local government be a 501c6? How can the DMO that should be self-sustaining be subsidized by other taxpayers? How can private retiree condo owners be assessed for a business district where they have no common business interest? Review the bylaws for compliance with NRS laws governing nonprofits. Clearly, a local government is subject to Nevada open meeting law, and the DMO refuses to so comply. This is Nevada's first and business improvement district, whereas taxation determined it is a local government. The commission needs to take a close look at this based on the above and many more related issues. Moving on to the next item to be read into public comment. It says public comment, Nevada Tax Commission, July 31, 2020. I am a property owner in Reno. While my property is not located in the downtown Reno Business Improvement District, DRBID, I have several friends who do. Until owning property in Reno, I was unaware of the Business Improvement District BID concept, so I did some research. Using various searches available to the general public, I learned that DRBID was established as a 501c6 in 2017 under DRBID's current president. The city of Reno created a BID area in 2018. Shortly thereafter, the city of Reno entered into agreement with DRBID to manage service and funds for the BID area. Prior to signing the agreement, the city deemed there would be no financial impact. Consequently, the city avoided soliciting competitive bids for the contract for BID management. Furthermore, the agreement between DRBID and the city of Reno says that if DRBID's budget has any changes greater than $50,000, DRBID must get approval of the city manager, not from the city council. Additionally, because DRBID is a private nonprofit, it need not comply with open meeting laws. As you most likely know, a BID generates an assessment against property owners in the BID area to pay for special benefits bestowed on those properties. Special benefits are services not ordinarily provided by the city. Since those outside the BID area do not receive these special benefits, they are not assessed the city's general fund and may not be used to pay for the BID's special benefits. In other words, it's important that the BID be self-supporting. In DRBID, the city of Reno agreed to give DRBID $875,000 out of general funds for the first 3 years. In May 2020, DRBID announced in its board meeting that the city of Reno promised an additional $190,000. Another example, all taxpayers inside and outside the BID area support RSCVA, and RSCVA donated $100,000 to DRBID in the current fiscal year and has pledged at least $50,000 for the next fiscal year. IRS requires 501c6 nonprofit organizations to file Form 990, 990EZ, or 990N annually. In a search on the IRS tax exempt organization website, as well as at https://projects.propublica.org/nonprofits, reveal no data indicating DRBID has failed to file Form 990 annually. Additional research explains that IRS criteria for 501c6 organizations mandate it be a membership organization with a meaningful extent of membership support, i.e. dues. DRBID's Second Amendment bylaws may be read at downtownreno.org and clearly state that there are no members. Without members, there can be no dues. In other words, DRBID's membership support is not meaningful because members support it's non-existent. Another criteria for a 501c6 organization is that members have a common business interest. It is difficult to see common business interest among the varied properties in Reno's BID area: churches, residents, casinos, city and county buildings, nonprofits, etc. Since BRD has no members, no dues, no obvious common business interest among its members, and has failed to file an annual Form 990, DRBID does not qualify to be a 501c6 nonprofit organization. Of significant importance to me as a property taxpayer outside the BID area, I'm concerned that general funds are being used to support DRBID. Because the procedure used by the City of Reno in contracting with DRBID, and because of DRBID's false claims to be a 501c6 nonprofit organization, there is no oversight or scrutiny regarding general funds going to DRBID. All taxpayers are subsidized all taxpayers are subsidizing DRBID. Hence, I pray that the Nevada Tax Commission will address this serious violation of no transparency and no accountability on DRBID for the City of Reno regarding general funds going to DRBID. Signed, Annette Coates. And the last comment that I have to read comes in from Inyo Fine Cannabis Dispensary, and it is addressed Nevada Tax Commission, CO Director Melanie Young, Chairman James DeVold, re Department of Taxation litigation case A-19-787004B, proposed settlement. Dear Chairman DeVold, I am David Goldwater, a partner in Inyo Fine Cannabis Dispensary. We have a single dispensary with a medical and adult use license in unincorporated Clark County. We are a plaintiff in the above referenced case. I urge you and your fellow commissioners in the strongest possible terms to reject this proposed settlement on behalf of the state and to rededicate your efforts to a resolution that includes all parties affected by the Marijuana Division's unfair process. The very nature of this litigation is that the process of evaluating and awarding the new recreational licenses was unfair. There is a trove of documents and sworn testimony that strongly suggests the process was indeed unfair. In fact, as you know, this case is in the middle of a trial where Judge Gonzalez is poised to decide this very issue. The settlement before you does not bring fairness to this process. It exacerbates the inequity caused by the unfair process. The basis of the settlement is to reallocate the licenses obtained unjustly to some, not all plaintiffs, based not on merit, but as a part of litigation strategy. It is akin to allowing bank robbers to get out of their crime by paying a fine with the proceeds of the bank robbery. Let Judge Gonzalez decide the issue of fairness without a settlement that divides the plaintiff with a payoff from ill-gotten gains. That is, proposal to the litigation strategy and not a settlement is abundantly clear because the agreement does not settle the case. The remaining plaintiffs can and will proceed with all the claims against the state. The settling parties have no ability to resolve these claims without the consent of the remaining plaintiffs. There is, therefore, no direct benefit to the state to enter into this agreement with only a few of the plaintiffs. In fact, as proposed, the partial settlement substantially impedes any ability for the state to resolve the case. All of the licenses that might be used as a part of a true global settlement are allocated to this group of plaintiffs, leaving the remaining plaintiffs with no reasonable alternatives for relief. In your March 9th, 2020 meeting when Chairman DeVold was empowered to negotiate settlements with all the parties. I rose in public comment to support the concept of settlement, but warned any strategic settlement that continues to award or give advantages to the larger companies is a threat to the smaller companies, a threat to the cannabis market and to the consumers as a whole. For example, if the state were to encourage settlements only between the larger entities that are plaintiffs in the litigation, it would be very effective litigation strategy, but not the best market strategy, or not the best for the state and or players in the market. This proposed agreement does exactly what I hoped the state would avoid. I'm acutely aware of how tiring and draining this litigation is. We have committed substantial resources in the pursuit of justice in this matter because we feel so strongly that we were treated unfairly. We are small and our resources are quite scarce compared to most all the plaintiffs in this case. But we believe in our position. The only conceivable benefit to the state by adopting this settlement is to engage in a strategy of attrition to end the litigation. Please do not be a party of this misplaced motivation. The settlement agreement requires the state to commit to things that are factually false and or violate state law. Paragraph 2 of the agreement, for example, appears to require the state to issue a brand new conditional license in violation of any statutory caps set forth in 463D.210 and 678B.260. Additionally, paragraph 7 requires the state to issue a determination to the court that the settling defendants have provided the information necessary in their respective applications to allow the state to conduct all necessary background checks and related actions. This is factually false, and the state has already committed under oath that it did not have, nor did they seek such information. It is a major point of the litigation. Certain provisions of the agreements require the state to grant advantages and privileges to the settling parties to which no other licensees have access. For example, paragraph 16 requires the state to expedite final inspections for only the settling parties. Paragraph 18 grants only the settling parties an automatic extension of the statutory mandated deadlines for obtaining final inspection. These are outrageous concessions and further evidence the state favors some over others in an unfair manner. There are several alternative ways in which to award licenses. The state of Washington, for example, avoided the of political influence by using a randomized lottery system to issue a limited number of licenses. Other states allow for unlimited licenses so that anyone that wants a license can get it. Nevada wisely chose a merit-based system of awarding a limited number of licenses. This assures that we have the most qualified operators in an efficient market that is of maximum benefit to Nevada citizens. The plaintiffs involved in the settlement were not chosen to be parties to this agreement based on merit. If we were to hypothetically assume the scoring were fair, I do not believe it was, there are plaintiffs that are a party to this settlement agreement who scored much lower than some of the plaintiffs who are not included in the settlement. I am unaware of exactly how many plaintiffs were chosen to be a party of the settlement. Mr. Chairman, I publicly offer to work with you and the state on how we might settle this litigation. I was never offered a license in Southern Nevada to settle as other plaintiffs were. I was never offered any other consideration contained in the settlement. Why? The settlement does not adhere to Nevada's merit-based system. The parties to this agreement arrogantly assume that they have the right to decide who gets a license based on no objective criteria whatsoever. This is singularly offensive not only to the excluded parties, but to the spirit of Nevada's alleged merit-based process. Our governor, as well as many other officials, have referred to Nevada's regulatory structure for cannabis as gold standard of regulation for the industry. I believe that prior to this round of licensing, our regulatory structure, enforcement, and monitoring were the best in the country. If this settlement is allowed to stand, what does this mean for not only this competitive process, but for all competitive processes involving the state? Our privileged few allowed to communicate with decision makers during the competitive process. Our applicants to expect evaluators to inconsistently score separate applications. Can division heads unilaterally expunge the records of applicants prior to application? Our favored applicants allowed information regarding scoring that other applicants are denied. Can obvious deficiencies in some application be overlooked based on a decision by the division boss rather than the letter of the law? The answer to all these questions will be yes, if this settlement stands and all of the plaintiffs are not treated fairly. As long as the booty of the endeavor is substantial enough, you can cheat the system and then settle the case with the same booty. That is not the gold standard of regulation. We are all tired of this litigation, and we are all drained of significant resources. But that should not discourage us in our quest for fairness. If we want to remain the gold standard, we must be willing to continue to do the work to assure all parties were treated fairly in this process. Settling the case with some plaintiffs for the purpose of expeditiousness falls short of the gold standard. In summary, I respectfully ask you reevaluate this partial settlement with a few plaintiffs. The settlement exacerbates the very nature of the case. Was the process fair at all? By settling with some as litigation strategy, we may not get the benefit of a judge full consideration. This settlement contains elements that are not consistent with Nevada law and exacerbate the perception that there are special treatment for some people. The settlement agreement violates the spirit of Nevada's merit-based system of awarding licenses to include plaintiffs favored by those who are favored by the process. Finally, if Nevada is to remain the gold standard of regulation in the cannabis industry, we must have a process that is transparent and fair to all. Thank you for your consideration. Respectfully, David Goldwater, CC, Commissioner Sharon Rigby, Commissioner Craig Witt, Commissioner George Gillespie, Commissioner Dr. Ann Bursey, Commissioner Randy Brown, Commissioner Francine Littman, and Commissioner Anthony Wren. And that concludes the public record to be read into, or public comment to be read into the record. And so at this time, Chairman, I would like to turn the time back to you.
Okay, thank you. Obviously, I let you run longer than the 3 minutes. I know you were probably getting tired reading there, so I kind of let those run a little bit longer, but I would now invite public comment. If there's a chance, you could please keep it to 3 minutes and not repeat things that have already been read into the record. That would be wonderful. So at this time, Tina, could I open it up as people raise their hand or would like to make public comment? Let's invite public comment now.
Hi, yes, if you could please raise your hand by dialing *9, and we will have public comment individually go through on that point. I'll give it a minute and then I will start public comment.
Chairman DeVold, while she's doing that, can we possibly take 2 minutes?
Yes, I believe so. Yeah, go ahead. Two minutes, and we'll be back at 2:52.
Thank you, Chairman Dole.
Okay, Tina, do you have some folks ready for public comment?
This is Kayla. Yes, we do. So phone number with the last 3 digits, 526. You may now unmute your telephone and provide public comment. And if you could please state and spell your name for the record.
I would also ask before you start, state your name and spell it for the record, but also could you disclose whether or not you're a party to the proposed settlement? Thank you.
Absolutely. This is Brandon Wigand. It's Wiegand. I'm the Regional General Manager of Nevada Organic Remedies, one of the settling parties in the case. NOR has a history as one of the leading marijuana dispensary operators in the state of Nevada. In the application process in 2018, we were ranked either first or second in all the jurisdictions we applied to. As a result, we were awarded 7 licenses, and we believe the DOT did its job in accepting, scoring, and ranking those applications. When this litigation began, we were the first company to intervene on the side of the state to support the licensing process. We've participated on the side of the state for more than 18 months. We've continued to defend the state's process throughout the lawsuit, even when the Department of Taxation raised a question regarding ownership of various applicants that we disagreed with. We've identified our company ownership to the satisfaction of the state so that it can confirm and perform any duties it has with respect to our ownership. This settlement provides a reasonable compromise. We believe the rankings were proper, that all 7 licenses awarded to NOR were properly awarded. We are, however, agreeing to reach a compromise to begin doing business. This will allow us to employ Nevadans. We currently employ over 150 individuals. Upon opening additional stores, we expect to employ at least 120 more. The litigation caused us to lay off our entire Reno team, which had been hired last year. We're looking forward to bringing many of those team members back to work as soon as possible. Additionally, each store opening generates many additional jobs for construction, business services, and support. This will also generate tax revenue for the state. We have provided millions in tax revenue already and expect that the additional stores will provide substantial additional tax revenue for the state at a time when our state needs that revenue most. We will continue supporting the state's effort to regulate this market and ensure it remains strong. For all those reasons, I ask the Commission to approve this settlement. Thank you.
Thank you, Mr. Wiegand. Tina, the next one. And again, if I could remind whoever is speaking, if you could state and spell your name and then state if you're a party to the settlement. Thank you.
My name is Dr. Nick Spiritos. I am not currently party to the lawsuit, but have been in the past. I would like to state that it seems almost virtually impossible to me that there can be any settlement of the lawsuit without reference to the law that was in place at the time that these applications were filed, and that exclusions and changes in the law made unilaterally and arbitrarily by Mr. Pupo and others was unacceptable, if not absolutely illegal. More importantly, Chairman Duvall, at the first meeting we had discussing this issue, stated that he would put this issue on an agenda to be thoroughly discussed, which he failed to do. When questioned about that at further meetings, Mr. Chairman, you then stated that this was in the process of being litigated and that this commission would not be taking up this issue as it was being litigated. And I would ask you to publicly state why at this time is it proper for you to take this up and the commission to take this upon itself in such short notice to resolve this issue when you've had months during which time period you refused to do your job and review this issue. Thank you. I'll wait your comment.
Thank you, Mr. Spiritos. I appreciate your comments. Tina, the next item.
Phone number ending in 000.
Thank you for your time today, Commissioners. For the record, my name is Leighton Kohler. I'm a board member and the corporate secretary for settling party Development Company, Inc., doing business as Planet 13. Our company has worked diligently towards settlement with the state of Nevada, and we are fully in support of the settlement you are reviewing today. This settlement will allow licensed marijuana operators to move forward opening the new licenses. The immediate effects will be greater citizen access to a product many in Nevada use for essential medical purposes, more jobs for Nevada employees who will work at the new dispensaries, and an increased tax base at a time when Nevada is looking for revenue and solutions to the ongoing downturn caused by the COVID pandemic. The industry and the state have come together to propose the solution, and we feel this settlement is firmly in the best interest of Nevada and request your approval. Thank you.
Thank you, Mr. Kohler. Next one, Tina.
Phone number 676.
Integral Associates.
I apologize. Phone number ending in 676. You are now unmuted on this end.
That's all right. Thank you. Thank you, Mr. Chairman and Director Young. My name is Todd Bice. I am legal counsel for Integral Associates, doing business with its subsidiaries as the Essence Dispensaries. That's BICE. We are not parties to the agreement, but we are one of the winning applicants from the 2018 round. And we have been a strident defender of the state and the department and the processes it implemented in selecting the licensees in December of 2018. The settlement agreement before you confirms that the litigation that the state and we have all been involved in for nearly 2 years now constitutes legal grounds for the granting of extensions to finalize the provisional licenses that were awarded in December of 2018. And that is why in Section 18 of the settlement agreement, you and the CCB are granting extensions. Our only comment on this is to reiterate that all of the successful 2018 applicants are entitled to the same equal treatment under the law and entitled to the same time frame in order to obtain final inspections and approvals. I am confident that neither this commission nor the CCB is suggesting otherwise, or that either of the bodies intend to treat the various licensees any differently. I want to thank the Attorney General's office that we have been working with to vigorously defend the state and vigorously defend its processes, because they were appropriate, and we were very pleased to be a successful applicant, and we look forward to moving forward. And I do believe this settlement at least partly makes that possible. Again, I reiterate, we're not parties to the settlement agreement. We intend to continue to defend our position and defend the state in the process. And I thank you, Mr. Chairman.
Thank you, Mr. Bice. The next one, Tina.
Phone number ending in 483.
Yes, thank you, commissioners. My name is Chris Rose. I am an attorney for Wellness Connection of Nevada, LLC, doing business as Cultivate. Wellness is a non-settling party. They were
Phone number ending in 48. I'm sorry, I believe our Zoom has froze. Can everyone hear?
Yeah,
I can hear.
Okay. Phone number ending in 483. Can you please start over?
Yes, thank you. This is Christopher Rose. I'm an attorney for Wellness Connection of Nevada, doing business as Cultivate. They are a party to the pending litigation. They are a non-settling party. They are a defendant, having obtained one license in the 2018 application process. Our comments are, and we understand that parties can settle litigation. Our concern is, as a licensee, as to the treatment of all the applicants and licensees. One of the prior comments mentioned that all the plaintiffs should be treated equally. Our position is that really all the applicants in this process should be treated equally. As a licensee, we hope that a regulatory authority would not show favoritism, As the commission is aware, that's what this case has been about. For the last year and a half, the plaintiffs have litigated the case claiming that the Department of Taxation engaged in favoritism. That's been the basis of everything that's led us to this litigation that we're in. Wellness is concerned that in a case where allegations of favoritism have dominated the day, that it is now being resolved through an agreement that requires favoritism by the regulatory authority in the form of expedited final inspections, expedited ownership transfers, location changes, awards of licenses, and then the 14-month extension for final inspection. So we want to voice our concerns with an agreement that favors certain licensees or applicants to the exclusion of others when we believe that the regulatory authority, be it the DOT or the CCB, should treat all of the applicants and licensees equally. Thank you.
Thank you, Mr. Rose. The next one, Tina.
Phone number ending in 218.
Hi, thank you, Chairman DeBold and Commissioners. My name is Jared Kahn. I represent Helping Hands Wellness Center, a settling defendant intervener. I'm pleased to be here today to speak in support of the INRI DOT litigation settlement. Helping Hands won 3 dispensary licenses in December 2018. The goal of Helping Hands dispensaries is to donate 70% of its profits to the affiliated nonprofit of Dr. Florence Jameson, the Volunteers in Medicine Clinic, which provides low-income residents with access to health care in our community, and to also donate to other nonprofits in the Vegas community. After a year and a half of litigation and the delays in creating the jobs and opportunities for Las Vegas residents, with this settlement, Helping Hands is pleased it will now be able to open its dispensary locations, support the tax revenues generated from cannabis sales, and begin fulfilling its mission to provide financial support to Dr. Jameson's Volunteers in Medicine Clinic. Helping Hands is certainly appreciative of the board's approval today and assisting resolving this challenging case after the parties expended thousands of hours over the past year to settle this matter. I thank you for the time.
Thank you, Mr. Kahn. I appreciate it. Tina, the next one.
We do not have any more public comment at this time.
Okay. Is there anyone else on the telephone? If you could use the raise your hand button on the screen. Is there any other public comment at this time?
Phone number ending in 308.
Greetings, members of the commission. My name is Matt McClure. I'm a resident of Las Vegas, Nevada, and I currently work in the cannabis industry in Las Vegas. I grew up in this town. I've always felt blessed to be a part of something as momentous as legal cannabis in my home state. During my time working in the state of Nevada's cannabis program, I've always felt an immense sense of pride in the work that we're doing. I felt that way because while I knew we weren't perfect, and few things are, I could confidently say that my team and those that regulate us were doing a great job. I've been blessed with the opportunity to work in cannabis in other states as well, states where Nevada's cannabis program is commonly referred to as a gold standard. I take immense pride in that, and I know that it's a standard our governor, through the newly formed CCB, is working to uphold. With the recent institution of the CCB, I felt that we were only going to improve the quality and integrity of our cannabis program. I feel this will be the first real test of whether or not that proves to be true. I believe that the approval of this settlement will not only diminish our standing as a gold standard in the industry, but will encourage more of the very issues you're attempting to resolve with this agreement. You'll set a dangerous precedent that the law of our voters passed and the rules we are all required to abide by don't apply if you have the means to file a lawsuit. The Department of Taxation's actions in the execution of the application process were carried out correctly and impartially in the way that the voters passed it. I don't believe that approval of the settlement will uphold the integrity of the rules and system we've all fought for and continue to operate within. Thank you for your time and consideration.
Thank you. Could you do me a favor and state and spell your name for me again? I apologize. That was hard to understand.
Sure. Matt, M-A-T-T, McClure, M-C, capital C, L-U-R-E.
Okay, thank you very much. Is there any other public comment? Okay, very good. We'll go on to agenda item number 2, which is the consent calendar. And I believe Commissioner Rigby, you wanted to make a motion regarding that item.
Yes, I would like to move that we pull this item off of the consent calendar in order to discuss it more fully.
Is there a second?
I would second Commissioner Brown.
Okay, motion and second by Commissioner Brown. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, great. The next item on the agenda is the consideration for approval and recommendation of the settlement agreement. Director Young, would you like to tee this up for us, please?
Yes, thank you. This item on the agenda is regarding the Department of Taxation litigation case number A-19-787004-B, pending in the 8th Judicial District Court, consolidated with case numbers A-18-785-818-W, A-18-786-357-W, and A-19-786-962-B, and A-19-787-035-C, and A-787-540-W, and -19-787-726-C, and A-19-801416B. And the department has the Attorney General's office here to present, and that will be Steve Shaborsky. I would like to turn the time over to the Attorney General's office. Thank you.
Good afternoon, Steve Shaborsky, S-T-E-V, Shaborsky, S-H-E-V as in Victor, O-R-S-K-I. I'm Chief Litigation Counsel for the Attorney General's office. It's my privilege and honor to represent the Department of Taxation in the consolidated cases pending before the Honorable Judge Elizabeth Gonzalez, Department 11, in the 8th Judicial District Court. It's been my privilege and honor of my life to serve Attorney General Aaron Ford, and I thank him for the opportunity to present partial settlement for your consideration and approval today. Previously, we had been here before, and you had authorized Chairman DeVol to attempt to negotiate and reach a resolution of the pending matters before Judge Gonzalez, and the partial settlement agreement for your consideration today is the result of those efforts. I should say that the agreement is a partial settlement. It is not a full settlement. Not all of the plaintiffs in that action are part of this agreement. It would potentially resolve a great deal of the case. It would specifically resolve the complaints filed by, if the settlement was to go through, the ETW plaintiffs as defined on the first page, the Nevada Wellness Center plaintiff, Qualcam plaintiffs, they're all described, the MM and Live Free plaintiffs, they're all described on page 1, right above the recital. You are not being asked to resolve the entire case. Unfortunately, as things go, that was not achieved, but I believe this partial settlement is a good one. It attempts to eliminate a great deal of liability for the state of Nevada. It allows, through the transfer of licenses, which could occur regardless of the settlement, between the parties to put a number of people back to work. It should be said that the parties who have not settled this are free to pursue their claims and have their day in court before the Honorable Judge Gonzalez, and attempt to nullify the 2018 marijuana retail competition and the conditional licenses awarded thereunder. They are free to do that and pursue those claims. Also, this agreement is in some ways contingent upon a filing of a motion before Judge Gonzalez to remove certain organizations, Nevada Organic Remedies, Green Martin Nevada, Lone Mountain Partners LLC, and Helping Hands Wellness from the preliminary injunction that Judge Gonzalez has ordered. Obviously, she could disagree, and the agreement would not function if that motion is not granted. I should say also that paragraph 13 is not part of the agreement. That's on page 5. That paragraph has been released on the public record today at a hearing on a motion for preliminary injunction brought by THC and Herbal Choice. That was denied by Judge Gonzalez, but in the process of that hearing, I, on behalf of the Attorney General's Office and the Department of Taxation as counsel, released paragraph 13. So that paragraph is not part of the agreement for your consideration. As with all compromise, it's certainly, things are not perfect, but it's the result of a negotiation, hundreds upon hundreds of hours of work by the parties. We think it's a good settlement. It will, if successful, will bring in much needed tax revenue for the state of Nevada at a time when it is desperately needed. It achieves significant litigation results for the Department of Taxation. And on that basis, I'd recommend it for your approval.
Okay, thank you, Mr. Szydłowski. At this time, I know we've got plenty of questions for the Attorney General's office. So is there any questions of Mr. Szydłowski or the staff at this time?
Yes, this is Commissioner Bursey. The proposed settlement agreement refers to, in several places, to tiers, T-I-E-R-S, of plaintiffs. And I may have missed it, but I did not see that term defined. And I wanted to know what is a tier of a plaintiff?
Certainly. Steve Szydłowski of the Attorney General's Office, for the record. A tier is a term of art in the pending litigation. There were 3 tiers. If you were a tier 1 entity, and I should say at the opening, the tiers are composed of groups of entities who were successful applicants in the September 2018 retail marijuana competition. And on tier 1, and this is a term that was used, tiers was a term used in the litigation. And so it's familiar to the parties in the litigation. That's why it shows up in the agreement, because if you're involved in the litigation, you're aware of the tier concept. And so let me define that for you. On tier 1 are entities that were successful applicants, but were not part of the litigation, and the Department of Taxation was able to confirm that it did not have a question about whether or not they had disclosed all prospective owners, officers, and board members, as the court at that time during the litigation believed that term to mean as a matter of law. This is at the preliminary injunction hearing in May. Well, let's strike that. Let's call it approximately August of 2019, because the preliminary injunction hearing went on for quite some time. I'm not sure of the exact date, whether it was August or July, when the tier definition or term came about. So I want to be as truthful with you as possible. I just don't remember whether it was August or July. On tier 2 are entities that were parties to the litigation, successful conditional licensees, and the department was able to eliminate a question whether or not they had disclosed each owner, prospective owner, officer, and board member. And you'll remember that language comes from ballot question 2, I believe it's NRS 453D 200 sub 6. On tier 3 were companies where that were parties to the litigation, they had intervened, and the Department of Taxation took the litigation position that it could not, at that time, eliminate a question of whether or not those entities on tier 3 had disclosed each prospective owner, officer, and board member.
Thank you.
I hope that answers you. It's a long explanation, but it was a part of the litigation.
I appreciate that. Thank you.
Other questions?
I have a quick one, Mr. Chairman.
Commissioner Wren?
Just to make sure I have a good understanding of this, Mr. Jaworski. The reason that we're here today is that the court mandated a settlement stipulation that at a prior meeting, we gave our chairman the authority to negotiate as best as he could with all parties and then bring it back to us. The settlement agreement isn't something that we asked for, something that's mandated by the court, correct?
Commissioner Wren, thank you for your question. Again, Steve Jaworski for the record, that's correct. This is the process of private negotiation in conjunction with Chairman DeVolt, but not court ordered.
Okay, and then my other question, in reading through the document, there's some questions about our authority and whether or not the CCB agrees with this. But if we, depending on what we do today, will this ever go to the CCB for an open hearing or their vote, or is there acknowledgement that we got from public comment that they're behind it good enough, or how does that actually work?
Sure. So Steve Jaworski again for the record. Thank you for your question, Commissioner Wren. Yes, this would go before, it expressly contemplates, although you have to read the agreement together, expressly contemplates that it will go to a public meeting before the CCB, because that's how the transfers of interest between the parties would happen. And so necessarily, as a consequence of this agreement, you would have a public hearing by the CCB. And as you've seen from the supporting materials, particularly a letter from Executive Director Klimas, the CCB has read this agreement, is in support of this agreement, considers itself bound by this agreement, but there will be a public hearing because that's how it functions in the future.
Okay, thank you.
And nothing would prevent the CCB from having another public hearing as well if it chose to.
Okay, thank you. Just kind of a follow-up, Mr. Jaworski. Is Judge Gonzalez aware of this entire agreement?
I believe she is, Chairman Steve Jaworski for the record. Chairman DeVolt, thank you for the question. I believe she is because there was a preliminary temporary restraining order motion, which is a term of art in litigation, where entities that were plaintiffs, non-settling plaintiffs, sought to have an injunction to prevent, and these are how I'm phrasing it, to prevent the tax commission from voting on this agreement, and believe that the agreement was improper. And so necessarily as part of that process, and there was argument about the agreement at that hearing, and necessarily as part of that process, Judge Gonzalez would be aware. We believe she was correct when she denied that motion this morning.
Okay. Other questions?
Mr. Chairman.
Go ahead, Commissioner Glasses.
Mr. Jaworski, Just for clarification purposes, is there any legal authority that says the Department of Taxation can bind the CCB?
Thank you for your, Steve Shaborsky for the record. Thank you for your question, Chairman Kalisas. Without getting into attorney-client privilege or my mental thoughts and impressions, I'm not aware of any.
So there's no statute or case law you're aware of?
Same proviso, without getting into my mental thoughts and impressions or any attorney-client privilege communications, not that I'm aware of, Mr. Commissioner.
I'm not asking you about your mental impressions. I'm asking you if you are aware of a case or statute that allows the Department of Taxation to commit the CCB and bind them to this agreement.
Not that I'm aware of, Mr. Commissioner.
In paragraph 22, there's representations and warranties. And those representations and warranties, let me ask the question this way first. So June 30th of this year, the Department of Taxation was removed by statute in enforcing, administering, issuing licenses on the marijuana. It would be June 30th, 2020. Correct?
You're asking me about the legal effect of the statutes that became Chapter 678A through D?
No, well, they didn't become it. 678A being were a separate set of statutes that were passed that became effective on July 1st.
Correct.
So when they became effective on July 1st, that took away any ability of the Department of Taxation to either issue, assign licenses, check backgrounds, do any enforcement. Correct? Marijuana licenses?
Cannabis licensees?
Yes.
I think that's a fair reading of those statutes and what the intent was.
Okay. So in paragraph 22, where it says, in the event the DOT is no longer responsible for performing any of the conditions, which you're referring to your agreement, that deals with inspection, deals with assigning licenses, deals with approving licenses, approving parties. Because earlier when Commissioner Wren asked you if there'd be a public hearing, if I heard you correctly, what you said was, as the applicants would come forward, there may be a hearing on them, but not a hearing as to this specific agreement, the terms and air. So since we know they can't do any of that anymore as of June 30th, isn't it the CCB that's going to be doing all fulfilling these conditions?
Well, I think to answer your question, the CCB would be doing some things, but obviously with respect to the pending litigation and taking litigation positions with respect to the motion practice that is contemplated here, that would not be the CCB.
I'm not asking about the motion.
Well, I'm trying to answer your question as best as I can, and I want to concentrate on the entirety of the agreement. But I understand your question is the CCB. We're not asking you to bind the CCB in any way. The CCB in the supporting materials has said that it's read the agreement, agrees with it, considers itself bound. But yes, to answer your question, the CCB would be doing that.
So again, I asked you about this earlier today in paragraph 22. It says the DOT represents and warrants that it has the authority to sign this agreement and bind the CCB. The phrase "and the bind the CCB" means something other than bind the CCB.
Well, I am wearing black today, but I'm not wearing a robe. My interpretation of that provision is that what is contemplated there is entering into this agreement to resolve the litigation, but it's the CCB that would bind. The CCB binds itself, and that's the import of Executive Director Klimas's letter and what is going to occur by public meeting in the future. So that is not my interpretation of that paragraph.
So Mr. Zhaversky, wouldn't it make sense to you then that we defer our vote send this to the CCB, let them do a public hearing, you explain it to them over there, they approve it, and then bring it back to us for our approval.
No, that is certainly something that could be done, but I know I don't agree with that. I think what should be done here is to approve this agreement. The CCB has said it will fulfill its part of it. And so that's the way it organically was set up, and I believe that is appropriate. The CCB has said that it believes that it is bound. There will be a public hearing, a public meeting to implement these terms. And so I don't agree that the best thing would be to defer action on this agreement. I think the agreement should be approved, and that we should go forward.
I didn't see anywhere in any letter that says they're going to have a public hearing over this agreement.
Well, it certainly is contemplated by this agreement, if you read it as a whole, that there is going to be a public hearing, because that is how the work is done that is contemplated in this agreement. They are by necessity, they're going to have public hearings over the transfers of interest. That's how that work is done.
George, can I interject a question?
I'm sorry, Commissioner Ram, go right ahead.
Thank you very much. I understand your concern with that language. Paragraph 13 has already been removed from this agreement. What would be the ramifications, if any, of us just removing paragraph 22? Seems to me like that would eliminate the problem.
I'm not sure. I mean, what I'm hearing Mr. Zavorsky saying is you got to read this as a whole. So as we start tearing out parts of this agreement, it's not going to have the same effect as you read it as a whole. I don't see what the issue is that we reserve our vote, send it over to CCB, let them do a 3-day notice, let them approve it, because the reality is this, as to the substance of the agreement, I got no issue with it. I think we're putting the cart before the horse procedurally. And I think it needs to go back to CCB. Let them take this comment and everybody's opinions and views, and then they can bring it back to us, because at the end of the day, if they're good with it, we're good with it. I mean, that's what's going to happen. I'm not willing to agree to that at this point until I know they're good with it.
And I would agree with that, but could we make our, if our recommendation is to approve it, can we make our recommendation contingent upon them approving it also? Just for expedience of time, if nothing else.
I hit the button the wrong way. I'm not used to this yet. No, Commissioner Wren, from the standpoint of having a motion that says that we'll condition our approval on their approval first, I got no problem with that. But again, I want to see them have a public hearing, and I want to see them approve these terms, and then we can approve it. I don't understand why it's coming to us first, frankly. And I know I'm going to hear, well, we're not a party. The Department of Taxation is a party, and it's clear under the statutes who has subject matter jurisdiction over all this is the CCB. I mean, the statutes are clear under 678. So yeah, I'm good with a motion like that, but I still firmly believe they have to approve it first.
Mr. Chairman, may I ask
Commissioner Rigby, please.
My question is for Mr. Zavorsky. On page 2 of the agreement, towards the bottom, let me see, I gotta find it here. Towards the bottom, we're talking about an option period following execution of the agreement. And this is between 2 of the parties to the agreement, but not the department. And it says it will pay $250,000, and then adds a caveat that says, or any other price on which the parties are able to agree. And I wanted to have you explain that for the record, how that's not too vague for this type of agreement, or if maybe substituting or the market value at the time, because there's a 5-year window of time and the value could fluctuate. But is there any other way to tighten up that language, or do you believe that language is not going to call the agreement into question?
Steve Jaworski for the record. Thank you for the question, Commissioner Rigby. I believe the language is enforceable. It is not too vague. It is language put in there by the parties who seek to use that option. I don't believe that $250,000 language anyway is intended to say that that's what they think the price is at this particular time or might be in the future. It's in there as an example, and that'll be left up to the parties who end up negotiating that put option to determine what is appropriate for that license if that agreement ever comes to fruition.
Okay. Thank you.
Commissioner Lippman, for the record, I've got a question for Mr. Jaworski. I'm comfortable that the CCB has approved and in very affirmative language from the executive director, CCing the Honorable Michael Douglas, who's the chair. So that letter is very precise and affirmative. However, it was drafted prior to the elimination of paragraph 13. And so I'd like to hear your comments, how Executive Director Klimas, was he aware of the elimination of paragraph 13? And in addition, I'd like to hear your response to the public comment about the authority for issuing conditional licenses through this agreement. Thank you.
Certainly. To answer your question, there was a litigation position that we took in response to the preliminary injunction motion that we would eliminate paragraph 13. I did not have a conversation with Executive Director Klimas beforehand. We thought, but we believe that was the best thing for the state of Nevada to do that, and it does not affect the agreement in any way material that we believe at all. With respect to the conditional licenses, there is no cap. The cap applies to final licensure. There is no cap for conditional licensure, and so we believe it is lawful.
Other questions?
Mr. Chairman, Commissioner Brown.
Commissioner Brown.
This is for Mr. Jaworski as well. I would like it if you would spend a few minutes with us in explaining in paragraphs 16, 18, and 35, what's the rationale or the state's thinking in I don't want to use the term special items, but what is the state's perspective or position on expedited inspection, on extension of the license period, and the distance requirement?
Sure. All these terms are process of negotiation. We do not view them as special consideration where we're putting someone ahead of anybody else. The CCB is working diligently to address the needs of all of the constituent parties that rely upon it. But these are certainly the process of negotiations, and that is where things that people wanted. With respect to the stores specifically, those stores are ready to be opened, and they're in a position where they are ready to go and employ Nevadans, and so that is why that is in there, and it's something that can be accomplished by the CCB very easily.
Could you also explain the distance requirement in paragraph 35?
Certainly. The distance requirement is a term that is in there that was wanted by between the parties themselves. It doesn't obligate the department in any way. It's something that the parties, the settling parties, the interveners, and the settling plaintiffs have agreed to amongst themselves. It's not something that pertains to the regulatory authority.
Thank you.
Any other questions?
Mr. Chair, George Colassus. This is a question to Commissioner Lippman. Francine, you said that you find that letter convincing. And my question to you is, if it's convincing, how can you explain to me, or how can you describe to me that the CCB had meetings and the public had an opportunity to address the CCB, and the CCB had an opportunity to respond to the public comments? That's what I'd like to know, and that I think is what everybody's missing. We're taking the public comments, and we have no legal authority to do anything about it, other than deny the settlement. And that's the extent of it. Who has the legal authority is the CCB. So, at what point in time did they hear the public comment? At what point in time? We know they didn't review the whole agreement because we just had a paragraph dropped out today. So how do we know the impact of that? And how do we know the impact of the public comment to the CCB about this agreement that we are obviously saying the department is binding them
to? Commissioner Colassus, one of the things that I find is that the Attorney General's office has worked in conjunction with the Cannabis Compliance Board, where they would not have sent a letter that says we agree to be bound by these obligations. So I'm a little bit confused on that, and it included the chairman of that. And I understand it wasn't in a public meeting, but I think they've had an opportunity to review the document. And if they had a big problem, they wouldn't write a letter saying that they would be okay being bound by these. I agree that there needs to be a public hearing, and they need to do their due diligence, but we're not telling them not to do their due diligence. I think that's one of the things that's important. And at the end of the day, the Cannabis Compliance Board isn't the one being sued in this arrangement. It's really the Department of Taxation, which is what we're responsible for. And that's kind of how I feel. I've spent an awful lot of time on this. I know this is not a perfect agreement, and I get that. It doesn't pull in everybody, but everybody's got competing needs, and it's a difficult concept for me to try and figure out how do I get everybody in the tent, and it was pretty obvious to me that wasn't possible. So you guys gave me the authority to go forth and try and get an agreement to the best of my ability, and that's kind of what I've tried to do here. And I understand and respect that it's not perfect, and I appreciate that.
I'm not questioning the work that was done. My question or my position is it's procedural. I don't think, because effectively what we're going to do is you're going to take away all public comment that people could make to the CCB, who has the legal authority to do something. We don't. We lost it all June 30th of 2020. And following through with what you're saying, maybe down the line they don't like it. So it unravels the whole settlement agreement and we're starting back from scratch again?
Well, I can't control that. I can't control that. That could happen.
I just don't.
May I respond to the question that was asked? It was actually not a question. It was obviously a long comment. But when
I apologize.
That's okay. Yes. I appreciate you stepping in. Chairman DeVold, I appreciate all that you've done on behalf of the state of Nevada. I'm looking at the letter, and it says in my read, the settlement agreement you are deliberating on today has been reviewed by the CCB. We have reviewed the requirements set forth in the agreement, including those that bind the CCB, and are committed to executing those obligations stated therein. That to me is clear and affirmative commitment in writing from the executive director, CCing the Honorable Michael Douglas, who was, of course, the Chief Justice of the Nevada Supreme Court.
Commissioner Lippman, I know when he was his district court judge and he worked at the DA's office. So I understand that. Now, if it's okay with you that there's no public comment, that's fine.
But
Mr. Chair, may I make a comment?
Certainly. Could I just say one thing, because I think George has got a really good point. I guess they could have a board meeting and unravel this whole thing, but are we any different place than where we are right now? I feel like it's the journey of 1,000 steps. It begins with something, and if we keep passing the buck around, I think we're the parties to the litigation, and I think I'm just trying to get it across the finish line. I know not everybody's going to be happy, and I'm not happy with the agreement because not everybody's inside this, and sometimes that's the best agreements is when not everybody's happy. So anyway, with that, Commissioner Rigby, you had something?
Well, I did want to say that we've watched this unfold over the last couple of years. It is a complex, very, very complicated situation. And we did delegate that responsibility to you, Mr. Chairman, to go through the litigation, deal with it on our behalf, come to a resolution and bring it to us. And in the meantime, the Cannabis Compliance Board was formed and going forward, I believe as of July 1 this year, begins to take on the responsibility for the marijuana compliance. And I think in a perfect world, there would be case law you could cite where something this unusual has happened, or a statute. I don't think they would bother to write a statute for such an unusual circumstance where one commission is then passing on responsibilities to another on a specific date. We can't just completely drop everything that was ongoing. In fact, I understand that the Cannabis Compliance Board was hoping that the Department of Taxation would resolve to the extent possible any of the pending litigation so that they could start with more of a clean slate. And yes, it's not perfect and doesn't resolve anything, but if it resolves 80% of the matters, puts them to bed, I think that this is a huge step forward. The Department of Taxation is the party, but the Tax Commission is the head of the Department of Taxation. We have agreed in prior meetings to review any settlement agreement. We are here at this meeting in order to do so. I think this is our time to say this is what has been put together, extremely complex. Get this portion of it resolved, and then we'll move forward without further responsibility, in my understanding, for the cannabis compliance. So with that said, I would move to approve the agreement.
I second the motion to approve the agreement.
Okay, there's a motion by Commissioner Rigby and a second by Commissioner Lippman. Is there any other discussion before we have the vote?
Mr. Chairman, it's Commissioner Brown, if you don't mind. I heard somebody make the suggestion that the motion be that we approve this condition on the Cannabis Control Board, similarly approving it. And I didn't hear, I don't know if Ms. Bordelove could help us or not, if that's even possible, or is that something that would not be permissible?
Rosalie Bordelove here for the record. That would be permissible. Your approval would, as long as it's clearly stated. I mean, that's not what's in the motion right now, but if they want to amend that motion or make a change, that type of approval would effectively take it out of your hands, and that could, upon an approval by the Cannabis Compliance Board, it would go into effect.
Commissioner Kalisas, would that be satisfactory to you as sort of middle ground, or?
If it's satisfactory to Commissioner Rigby and she's willing to amendment, I'd vote for that, yes.
Okay, I'll withdraw the motion that I had made. Before making another motion, should I include that we're excluding paragraph 13? Okay.
Rosalie Bourlove here, yes. That would be helpful to be in the motion, just so it's clear.
Okay. I would move that we approve the recommended settlement agreement in RE Department of Taxation Litigation with the removal of paragraph 13 and contingent upon the approval by the Cannabis Compliance Board.
I second the motion as revised.
Okay, revised motion and second by Commissioner Rigby and Commissioner Littman. Is there any other discussion? All those in favor, please signify by saying aye.
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 Aye. Chair votes aye. Is there anyone opposed? Okay, motion passes. Thank you, everyone. Our next meeting is August the 17th. I'll open it up for public comment again. Tina, if you could open the lines again. Is there any public comment on the telephone?
This is Kayla Yost. Please state and spell your name for the record, and please let us know if you are a settling party. Phone number ending in 698, you are allowed to speak.
Thank you. This is David Goldwater. I am not a settling party. I know that all that will remain of this entire imbroglio is the public record, so I did want to make sure that despite Commissioner DeVol's representations, not all parties were equally consulted or worked with in order to settle this case. We were never contacted. We were never offered the same settlement that the settling parties were, either by Mr. DeVold or Mr. Saborski. I did not hear in the discussion of this matter what the criteria was for people who were going to be a party to this settlement. What was it that compelled the commission to settle with some parties and not others? Lastly, I did not hear any discussion of the urgency regarding this matter. There seemed to be an urgency on behalf of the state to settle a part of the case. As I mentioned in my letter, other than litigation strategy, divide and conquer, I don't see the sense of urgency. Mr. Chairman, thank you for allowing me this time to finish the record.
Mr. Goldman, thank you very much. I appreciate it. Is there any other public comment?
This is Kayla Yost again. I was going to ask, please raise your hand by dialing *9. Just a reminder if there is any more public comment. Phone number ending in 585. You can go ahead and speak.
This is Dr. Nick Spiritos once again. I'd like to ask the commission or put out into the public domain. It's quite surprising that after a year and a half that the commission had the ability to oversee, one, the process, and two, the issue of compliance with the law of the applications. And they relieved themselves, you relieved yourselves of that responsibility through all of this time, yet now at this last minute have decided to take it upon yourselves to address this issue when you've had a year and a half plus to do the same. I find it strikingly impossible to believe that there's an urgency at this point, and I lack complete understanding of how this could come about. Thank you.
Thank you, Mr. Spiritos. Any other public comment?
This is Kayla Yost. I do not see any more public comment.
Okay. Very good. Thank you, everyone, for your diligence and the amount of time and energy in trying to get an agreement across the finish line. I very much appreciate each and every one of you on a Friday afternoon for doing this. So thanks so much. And I also want to thank the Attorney General's office, Mr. Shavorsky, and Attorney General Ford for helping us across the finish line. Thank you all and have a good weekend.
Mr. Chairman.
Yes.
Thank you.
All right. Bye.